Items. Item number 2, SB 908 from Senator Weiland, is not on the agenda. It's been pulled. In addition, Senator Yee will not be with us today unless we are very surprised, but as of now, he will not be able to join us. So we will hear presentations from authors or their representatives. We will take public comment, but we will not vote today. The plan is to vote when Senator Yee is with us tomorrow after session. So if there's any change to that, we will post it. But as of now, this committee will reconvene after session tomorrow on Thursday. With that, we have one author with us. Senator Flores, do you want to present item number 4, SB 1121?
Thank you, Mr. Chairman. I appreciate the opportunity. I understand the mechanics. But I would like to, since this will be the policy committee before, if successful, going to the floor, I'd like to say that, number one, I have about 200 days left in my career in the California State Senate. I've worked here since 1987. I'm going to age myself prior to term limits as a staffer. And as I got to the State Assembly, we had a very clear agenda that farm workers and farmers should find the proper balance in terms of my district, in terms of representation. All of you should know that we've worked very diligently to make sure farm workers weren't packed in vans and had forward-facing seats in the State Assembly. That was a very important bill that was signed by Governor Davis. We then have moved on to deal with pesticide drift. But this is, in my last 200 days, one of my last closing agenda items for me as a legislator, something I'd like to close the books on, if you will, before I leave this place. Just to give you some context, my great-grandfather worked in the fields back in the early 20s and 30s, and there was no overtime for row workers at that time. His daughter, my grandmother, worked the fields, and there was no overtime. My father worked the fields, and there was no overtime over 8 hours, and I worked in agriculture, and there was no overtime. We've had an exemption for agricultural workers for farm laborers since 1941 on the books. And even though labor has made great strides here in the Capitol, we all remember in 1998 when we went from a 40-hour work week to an 8-hour day, that workers in California should have overtime over 8 hours. Even in that great push, farm workers were forgotten. We continue to have the exemption on the books, and this bill simply does something very simple. It eliminates an exemption. It's probably the easiest bill in the world. It eliminates an exemption that's been on the books, and it's long overdue. We believe that farm workers who work over 8 hours should have time and a half. We believe farm workers who are, in many cases, as we've read, during the heat reg battles here in the California Capitol, work those long hours. And as you probably know, when the bell pepper truck is ready to go to market, when the last truck needs to move off the fields, what happens is that farm workers work very diligently in order to make sure the truck isn't staying overnight. Sometimes they work 10, 11, 12 hours, and we believe that they should get time and a half after 8 hours, just like any other worker in the state of California. And so with that, we are presenting this bill. It's a very important bill, and quite frankly, I think it's long, long overdue for farm workers to have this type of protection and this type of wages. And as you know, many farm workers, even with all of their wages, may not hit the poverty level. And I understand that there are some complexities with agriculture in terms of their own margins, but it clearly does not outweigh the moral issue that farm workers should have overtime over 8 hours, just like any construction worker, just like anyone else working in the sun. And hopefully this bill would do that. So I hope that the bill can pass, and I do have witnesses' support.
Mr. Chairman and members, Mark Shaw, California Rural Legal Assistance Foundation, happy to support this bill. I'm glad that Senator Flores has brought it forward. It's, as he said, long overdue. Farm workers work some of the longest hours for some of the lowest wages of any group of employees in California, and they and their families certainly deserve a fair wage, and this bill will bring it to them.
Yes. Anyone else in support? Good morning, Caitlin.
Good morning, Mr. Chair and members. Caitlin Vega for the California Labor Federation. We see this as an extremely important bill. This committee has heard many times discussions about the importance of overtime and the importance of the 8-hour day. We see no group of workers more in need or more deserving. Farm workers do some of the hardest labor, work in some of the most unsafe conditions, and we think that overtime laws create an incentive for employers to staff appropriately and not work one group of workers kind of to the maximum that they possibly can. We think it's extremely important for health and safety, and we think it's just an important issue of equity. So we're here in strong support.
Thank you.
Anna Furman on behalf of the California Nurses Association, also in strong support for the reasons already stated.
Shane Gussman on behalf of the Teamsters, United Food and Commercial Workers, International Longshore and Warehouse Union, the Machinists, and the Amalgamated Transit Union in support.
Mr. Chair and members, Doug Kim with the applicants' attorneys and a former farm worker in support.
Good morning, David Lowe for the California Employment Lawyers Association. We're also in strong support of this bill. We also see it as both an important worker safety issue and also an issue of equality and equity. We don't think that farm workers should be treated as second-class citizens any longer. Thank you.
Okay. Are there any witnesses in opposition? Good morning.
Good morning, Mr. Chairman. I'm Brian Little with the California Farm Bureau Federation in opposition to the bill. We're here because we're concerned that an increase of probably 10% in the cost of labor for agricultural producers in California will help to choke off a nascent recovery in the industry where folks are just beginning to get their feet back under them now that in some places they have some water and markets are beginning to recover again. I'd also point out that this particular provision of the law could be changed by the Industrial Welfare Commission, so there's already a mechanism to do this. Kind of wonder why it's necessary for the legislature to act. Also, any collective bargaining agreement, and there are collective bargaining agreements in agriculture, can set different rules for overtime and hours worked and a variety of other working conditions. So on behalf of the 80,000 members of the California Farm Bureau Federation, I'd urge you a no vote on this bill when you get around to voting on it. And I thank you very much for your time and attention.
Thank you. Other witnesses in opposition?
Good morning. Thank you, Mr. Chair. Chris Valadez, representing the California Grape and Tree Fruit League, and we too are in opposition, and we mainly look at this issue as one of competition and competitiveness and see it as one that decreases the competitiveness of the California family farm, particularly when we realize that the California family farmer competes not only amongst their competitors within the state, but also in other states and with producers internationally. So we see a bill, SB 1121, negatively affecting competition, but not only that, it affects the California family farmer and the margins that we discussed today, but that margin has to be made up somewhere because we know production costs are going to increase, and we also realize that labor costs, should this bill become law, would increase. So where is that margin made up? You look back into labor costs. Ultimately, what this bill can do is add pressure to the California family farmer, make them more uncompetitive with their competitors in the state, outside of the state, and internationally, but could even affect the wages of workers negatively. You can pressure the California family farm to look at where they're going to make up the margins. You look at the labor costs, and you come up with the decision that, well, do you cut back on overtime because California already has current overtime for ag workers, which is not the case throughout the nation. California is already the most progressive in that respect. So you want to, I think, be very careful in your consideration of this bill moving forward to make sure that you keep California agriculture competitive nationally, internationally, but that you also do the right thing by the worker and to make sure that we do, within this sensitive economy and moving forward, we can continue to remain strong, grow the industry, and even add more workers to become more productive to when we're dealing with harvesting of the crops and moving forward and adding more to California's agricultural palette. So we urge opposition when you do get around to the vote, and we thank you for your time.
Thank you.
Kelly McKechnie on behalf of Western Growers. California farmers are price takers, not price makers, and any addition to production costs will severely hurt farmers on the national and international level. And also keep in mind that that this will severely also cut agricultural pay and whatnot, because they could just add on labor. So we're in opposition to the bill and hope that you vote no. Thank you.
Thank you.
Crystal Jack on behalf of the Alliance of Western Milk Producers, Nisei Farmers League, California Citrus Mutual, California Cotton Ginners and Growers Associations, Western Agricultural Processors Association, and the California Tomato Growers Association, all in opposition. Thank you.
You did that well, Crystal.
Mr. Chair and members, Kendra Dijoga with the Gualco Group on behalf of the California Association of Wine Grape Growers. We just wanted to echo the comments previously made, especially those of the California Grape and Tree Fruit League.
Thank you.
Kyla Christopherson on behalf of the California Chamber of Commerce. We also are opposed for the reasons stated. We believe that this will harm jobs and the economy ultimately. Thank you.
Thank you, Kyla.
Good morning, Tricia Geringer with the Agricultural Council of California, representing over 30 farmer-owned cooperatives from throughout the state in opposition for the reasons previously stated. Thank you.
Thank you.
Dennis Albiani, California Grain and Feed, California Seed, California Pear Growers, California Bean Shippers, and several other agricultural associations. For the previous reasons, we oppose as well. Thank you.
Steve Cruz for the Family Winemakers of California.
Thank you. Any questions? Senator Flores, would you like to close?
Yes, thank you, Mr. Chairman. First and foremost, let me say that this legislature has done and made great strides with the ag community last year. We passed an historic water bond, putting it on this ballot for one reason: to reduce production costs for agriculture. This is why we're doing this. This was the battle. So I would simply say, as we allow for more water to be produced for the Central Valley to get production costs down, that we share a little bit. That this legislature recognizes that we reach out to agriculture, we work with agriculture, we pass a water bond with agriculture, much to the angst of a lot of folks around this place. And indeed, when we find that when this is actually completed, we're going to find production costs are going to be very competitive. We're going to have enough water. Water costs aren't going to be skyrocketing. And I simply say that as the legislature continues to work with agriculture to bring those production costs down, we simply share a couple of hours, a time and a half, for the workers who, at the end of the day, may be working 12, 13, 14-hour shifts in order to get that crop to the truck. And I think that's more than fair in terms of what this legislature has done for everyone who just came up in opposition. And I think that hopefully this legislature will recognize that we have to have a balance of farm workers and farmers. And clearly, as the ag community is in Washington asking for a guest worker program with an argument that we don't have enough workers in California, I don't know a worker in the United States that won't say, maybe let's go out and pick in California because there they pay overtime. There may be a little more money on the table for farm workers. And this is how you draw workers to your state. You draw them because you're fair, you have good laws, and more importantly, you might pay the wages necessary so people might be able to sustain their families. And I think that is really what this bill is about.
Senator Leno.
I had heard on NPR the other day a story about 2/3 of California's farm workers without any kind of health care coverage. Is that probably an accurate statement?
It's a very accurate statement.
So majority of farm workers have no health benefits, pension benefits?
No pension benefits.
Paid vacations?
No paid vacations.
This seems like a very minor step forward to bring some respect and dignity to people who are putting food on our tables and doing some of the hardest labor around.
And you're right, Senator Leno. And in fact, all of the arguments by industry that just came up were the very same arguments that labor heard when we wanted to move to an 8-hour standard back in 1998. So the argument is no different. And in fact, as you know, in 1998, as this law was passed, this economy did much better, so much so we used to have a surplus in the year 1999 and 2000. So I didn't see the doom and devastation here. And of course, we're never going to be able to pay $1 an hour as they do in Chile growing grapes. And I hope that we would never do that. we have to remain competitive in this particular environment, and the industry needs to maintain and be competitive. And clearly, they also have agricultural entities in other nations as well. There are grape growers in Delano today that have fields in Chile. They balance out their own portfolios with different types of fields in other places. So this is not, in many cases, the sole way to deal with this. This is simply trying to bring some dignity to workers who, at the end of the day, believe it or not, work just as hard as any other worker in California after 8 hours, and they clearly deserve the same protection that we're given to our labor community when we fought and won a very large battle for the 8-hour workday. This simply pulls all workers into the same category.
Without any intent to speak hyperbolically, the arguments that we just heard in opposition really, if you look in the history books, are the same arguments used by Confederate farmers in the 19th century, that the economy would tank and it would be all destruction. So I'm happy to support the bill.
Any other questions or comments? Senator Weiland?
Yes. Without making a comment about the 19th century, that strikes me about the comments the other day about the Holocaust, which I think are way over the top. I absolutely understand this is hard manual work, and anyone who's done it, and I did a lot of it when I was younger, knows it. It is hard work, and you get tired. There's absolutely no doubt about it. And I understand that. I think one thing that we have to recognize, and it's not to do with this. I mean, this is a very legitimate concern, all of it. And same thing with health care, and if someone does this, for most of their life, having a way to live after that. One thing I do think we have to recognize, just as a fact, is that, and you mentioned it, Senator, with the portfolio, there does come a point at which certain industries will increasingly move offshore, just as they have in other areas, and we just have to be honest about it. And it doesn't mean that we may not choose, for those who remain here, to give them more. When I lived in Europe many years ago, people who worked in the restaurant industry made a decent living. And what it meant was there were just fewer restaurants and the costs were higher. But those who worked there, had good working conditions and decent living. And I just think we need to know that, recognize that. In my area, we have a big floriculture, huge industry. A substantial part of that in certain areas, like the poinsettias, have just moved down to Guatemala. This is part of the world that we live in. And somehow I'm actually more concerned in some ways. Well, I'm concerned about my flower growers, but I'm also concerned about the manufacturing that we have to deal with. The only other thing about water is, and we don't need to go into this today, but I understand that the Endangered Species Act allows, and Senator Duchesne and I had a brief discussion about this, but I've checked it out a little bit more, allows in the instance of extreme economic hardship for there to be an exemption that must be approved by 2 U.S. secretaries. One, I think, is the Secretary of the Interior. And that is something that, if no other committee will take it up, I think we ought to find out so we can try to help people down there, some of those farm workers who are just having a terrible, terrible, terrible time. And the final thing would be, I know you held, Senator Flores, you held hearings on EDD quite a while ago. And I know and I appreciate that, and that's still a problem because I get those calls in my office.
Anyone else? Senator Duchesne.
I apologize being late. I didn't realize this would be the first bill up because I did want to hear some of the testimony. I'm just a little concerned that this is a different universe and that somehow, Senator, there may need to be a slightly different accommodation, and I don't know what it is. The principle you're going after is certainly not inappropriate to say that everybody is sort of treated the same, and workers are workers, and certainly these workers actually work harder than most others, so there's something to be said for the 8-hour day. But I'm a little concerned about applying the meal and rest periods the same and some of those things in the same fashion you would in a more controlled environment, and where you're not facing the sort of weather and the harvest has to come in X number of days, weeks, whatever it is. And it is only certain times of the year, I suspect, that this is a problem, right? I mean, I didn't hear all the other, but maybe you can help me out with that a little bit.
Well, Senator Cheney knows that for irrigators or for folks who are working in various types of production, let me use one example.
Some are the year-round
potato
folks,
sheds or something of that sort. Those workers are obviously given accommodation. This is really about field row workers, those who are in the fields, those who are bending and harvesting and using their back, and others. I can say that we're always willing to work with Senator Cheney. We share very large swaths of agricultural production. Of course, my area produces probably one of the highest levels of agriculture in the world. So I think we can continue to have discussions, Senator Cheney, but the principle is something that I really strongly believe in, and that 8 hours is indeed a standard that all workers should share. If not, then we should revisit it for every worker. And I don't think we're going to do that, because it was a very hard-fought battle to bring the 8-hour workday to this legislature and sign it. So I think in the end, when you think about the very need for bringing harvest, those things that may perish and need the extra work in many times.
They end up. There's almost no way you can do it without a 60-hour work week in certain cases, and so the question is,
only in certain weeks and only in certain times. So this is not one of those year-round. We're always going to hit overtime. This is, in many cases, the last 2 weeks of the crop having to come in, and I think it's a question for the legislature of whether or not, those workers ought to be paid at that critical time and a half, for example, over 8 hours. And I would understand if this was going to be 8 hours every day overtime, and it's constantly. But this is, as you know, seasonal work. If you're working almonds, for example, you're doing some pruning. Most of it is with shakers today. It's mostly mechanized, and so I don't really see this as the largest burden that's been portrayed by the industry. Yes, it will be tough in the few weeks of the year. Yes, it will be tough during the time of harvest when you have to get things out of the field and into a truck. But I don't see this as an ongoing overtime issue. This certainly isn't firefighters who are receiving overtime on a constant basis in many cases. This is a very small portion of weeks during a year where farm workers are working in the toughest conditions. I guarantee you that this coincides with the very heat regs that we fought so hard about.
True.
This is when they're working. This is why farm workers die in many cases, because they're on their 11th, 12th, 13th, 14th hour. And at the minimum, we can give them time and a half for that. That's just kind of my thought on it. But we'll always work with Senator Cheney, my seatmate for the last 6 years.
The industry. It's not so much me. I'm just concerned about how different some of the circumstances may be, and whether to consider some of the meal and rest period application is a little odd. It's difficult to pick an exact time. And the other would be whether we think about the week overtime versus the daily overtime. The 8 hour, I think I agree with you. I mean, people that are doing that for more than 8 hours should be paid extra, but maybe it's a 48-hour work week, or rather than a 40-hour in which the week thing applies. In other words, if you did 8 hours a day, but it was 6 days during the harvest season, I don't know. It just seems to me there may be some other accommodations that might be made, and certainly during the hot periods, it's even more critical that you have at least some compensation for it. So, I mean, I'm having unfortunately not heard all of the arguments, but knowing generally what they would be. Senator Weiland's right. People are moving what they're moving wherever they're moving it. Tomatoes have moved to Baja, and wine, some grapes are being grown both in Baja and in Chile and in Argentina and a lot of other places, and that's just the market. After this week, we may get a lot of workers back from Arizona, and whatever. So it kind of, what goes around comes around. in different ways. So I'm willing to help you move this bill forward, but I would encourage you to continue to talk to the industry about ways that this might be accommodated so that we don't disrupt the industry in a way that could work against us. I mean, it's an important industry for us. It's not like it can totally move around, but it's important that we continue to have an agricultural base in California, and we need to make sure that we're doing things that are consistent with maintaining it. So.
Would you like to close second time?
Yes, I would. I'm sorry, Mr. Chairman. It takes so much time. Obviously, it's been mentioned a couple of times, and I do appreciate Senator Cheney's comments. Workers in all kinds of industries clearly do get overtime over 8 hours. Workers in industries, even in perishable goods, get overtime, whether you're a truck driver, whether you're a warehouse worker, whether you're production and cannery, they all get overtime. The only folks that aren't in this value chain are the field workers. And I think for us, we ought to complete the value chain and simply shoot for a standard that allows for fairness. And as I mentioned, this is a very, very old exemption. It's been on the books since 1941. And I think as I've said, my great-grandfather, my grandmother, my father, have all worked under the same regimen, and the world has changed since then, and we ought to change with it. So we would ask tomorrow, Mr. Chairman, for an aye vote.
Okay. Just so that everybody who may not be aware of the situation here today, Senator Yee is not going to be joining us today, so as we did the last meeting, we're holding public testimony, hearing presentation with the idea that with the necessary waivers, we will actually vote tomorrow after session. So just so everyone knows. Senator Flores, thank you for your commitment and your compassion of this issue, and I can't completely agree on issues like water, but I know where your commitment is in terms of the welfare of these workers and ultimately for the employers as well. So thank you. We'll look forward to seeing you tomorrow. Thank you. Thank you. Senator, I slipped. Assemblymember Ma. I just think of all the representatives from San Francisco as being senatorial.
Thank you, Mr. Chair and members. Assembly Bill 586 is a cleanup bill to Assembly Bill 1227 by Assemblymember Feuer. It was signed last year, and it inadvertently removed members of San Francisco's public safety community from receiving full disability pay for a period of 1 year when they are injured during the course of work. AB 586 would clarify that San Francisco public safety officers who not already are entitled to these benefits through the city charter will qualify for the program up to set up by AB 1227 and make such provisions retroactive to the enactment of the new law. With me here to testify is Michael Corbett, San Francisco City and County Representative, and Randy Perry of PORAC.
Looks like you're up, Mr. Perry.
Mr. Chairman, members, Randy Perry there and Reed & Associates on behalf of PORAC. As the one who committed the drafting error, I'm here for a mea culpa and ask the support. It was very simple that we were trying to amend out the police officers of the city and county of San Francisco who are covered and have a similar benefit under the charter and asked to be exempted from the bill. So by adding city and county, we didn't realize we actually eliminated other public employees who were already in this section and receiving the benefit, the deputy sheriffs and DA investigators and the like. So we were attempting to put them back in. And we make it retroactive January 1 because since January 1, they no longer have this benefit. So,
as long as you don't get overtime for doing this.
Correct.
Mr. Chair, draw a line somewhere with attorneys and lobbyists.
Mr. Chair, members of the committee, Michael Corbett on behalf of San Francisco City and County, we fully support this. And as Mr. Perry said, this is just the result of an oversight that was not caught either by the people affected or by the city and county until the bill had actually been enacted. So this is just an attempt to restore fairness to the system.
Thank you, Michael. Any witnesses in support? Doug, didn't get overtime as a farm worker and don't get it as a lobbyist.
I came with the applicant's attorneys and we support the bill.
Thank you. Any other witnesses in support? Any witnesses in opposition? Any questions from the committee?
I move the bill.
Thank you, Senator Leno. Would you like to close, Ms. Vaughn?
Respectfully ask for your aye vote.
Okay. You will get it at the appropriate time. Thank you. We don't, but we're going to just to be careful. So I'll ask the secretary to call a roll for quorum.
Senator Desaunier.
Here.
Desaunier here. Senator Wyland.
Here.
Wyland here. Senator Denise Moreno Duchesne. Duchesne here. Senator Dennis Hollingsworth. Senator Mark Leno.
Here.
Leno here. Senator Leland Yee.
Senator Duchesne, would you like to present your item and the sergeants? We'll let Senator Hollingsworth know that he's up. It's item number 5, SB 1370.
Thank you very much, Mr. Chairman and members. Initially, I want to thank the committee for working with us on this bill and their analysis, and to acknowledge that there are some outstanding concerns from the California Employment Law Council, who have courteously removed their opposition at the moment, and are willing to continue to work with ourselves and the committee staff to address any concern regarding impacts on potential litigation practices that might change. We aren't quite sure how that would work and whether there would be a problem, but we're happy to continue to discuss it with them to ensure that this doesn't change how people approach it. The truth of this is to, of all the odd things, is to allow California workers to be on an even par with out-of-state workers. For some reason that I don't have a Randy Perry here to tell me what the drafting reason was, but apparently, once upon a time in history, this legislature made the decision to allow employment contracts if you were a commission employee, to require contracts if you were out of state, but to not, for some reason, apply that to in-state employees. It doesn't make a lot of sense. It has now been found by a court to be a violation of the Interstate Commerce Clause, and what we seek to do simply with this bill is to require that all commission contracts, whether you are with a company domiciled in California or out of state, be written so that there's clarity. I actually think it would help eliminate litigation potentially, because you'd actually have a contract, and it would be clear that if you are a commission employee, you wouldn't have as many fights with people over whether you were paid the appropriate commission, because you would have a document in writing. And the idea is to allow and to require, in fact, that there be written contracts for commission employees. Ask for your aye vote.
Thank you. Witnesses in support.
Good afternoon, Senator. I'm Larry Doyle on behalf of the Conference of California Bar Associations. We're the sponsor of the bill. Senator Duchesne summarized it very well, and I don't really have a lot to add. As it currently stands, Labor Code Section 2751 is a trap for the unwary, in that it purports to provide protections to certain workers which no longer exist because the federal court has held it to be unconstitutional. It's actually happened in practice that people have relied upon this statute and found that it doesn't support them. There are two ways to go with it. We can either repeal it and remove the protections that the statute already provides, or that we can expand it to extend to all employees working on a commission basis, because and we felt that it seemed to be the better idea to go in the latter direction, because, as Senator Duchesne pointed out, it is probably best practice now with all businesses, and it provides certainty, it provides protection, and it's the better way to go. So for that reason, we hope that you will support the bill.
Okay. Other witnesses in support. Start down at the table.
Mr. Chair, Senators, my name is Michael Sohigian. I am speaking for the sponsor of the bill, the California Conference of Bar Associations. I am a practicing lawyer in Los Angeles. I actually have represented parties suing on commission agreements. I have sued on Labor Code 2751, and I have had a court grant a motion for judgment on the pleadings against my client based on the district court decision in Lett versus Paymentech invalidating Labor Code 2751 on Commerce Clause and equal protection grounds. So I know firsthand, or I guess first and a half hand, it was really my client who suffered the real slings and arrows of that, but I know what it's like to depend on legal protection that proves illusory in this regard. Deleting the offending language is a way to restore to the people of California, both the employers and employees, the protections that 2751 provided. It is my view, and I echo the Senator and Mr. Doyle in this, that the Bill 1370 actually protects both employers and employees. Obviously, it helps commissioned employees who would fall under the definitions that the Labor Commission has already promulgated regarding commissions. That is, that they are compensated for activity which is primarily involved in the sale of products or services based on a percentage of the sale price, and you can find that in Labor Code Section 204.1. You can find that in the opinion of the California Supreme Court in Ramirez versus Yosemite Water. I may have that case site wrong, and also in the Court of Appeal decision in Keys Motors. Those workers, of course, would be protected by having a written commission agreement. And in my view, the employer likewise would be protected by having a written commission agreement, because in case of any dispute, there you have it in writing. What are the terms of the agreement? How is it being paid? Are you actually a commissioned employee? Is your commission based on sales or some other issue? And so once it's in black and white, not only is it best practices, but it also helps all the employers in this state. So that's why I, with the Conference of Bar Associations, urge an aye vote, I guess, tomorrow.
Senator Leno.
Yes, a question. If Let v. Paymentech was decided in 1999, how is it that we've waited 11 years to take this up?
Well, that's really a question for you folks, I think.
Have we attempted to?
To our attention.
This has just been brought to our attention. Yeah.
I think, Senator, it has to do with the fact that even though lawyers like Mr. Sahigian have encountered issues in terms of relying upon the statute and having the protections that provide prove illusory, it's not necessarily the first thing you do to think, okay, let's go change the statute. But it is out there. It is a stumbling block, and better late than never, I guess.
Yeah, just curious.
My own experience, it was that the case in which I suffered the defeat was 2007, and I had to figure out how to get it before the state legislature, and that took a while, obviously.
The wheels of justice move slowly, sometimes very slowly.
The lesson is to bring it directly to members rather than to go through the Bar Association, but it worked. I got the letter from them this year, last fall, and here we are.
They were waiting for the right author, no doubt.
That must have been it.
Other witnesses in support.
Good morning, Mr. Chair and Senators. David Lowe for the California Employment Lawyers Association. I just wanted to add my perspective as practicing plaintiff side employment lawyer. Unpaid commission claims are a substantial part of my practice, and a very large proportion of those claims would have been avoided had the commission plans been in writing. So I can tell you with absolute certainty that this bill would substantially reduce the number of lawsuits that arise from unpaid commission disputes, and it would be a very, very helpful bill in that respect.
You're going into another line of work?
Then what?
There's always other kinds of claims out there.
The new line of work will be writing the commission contracts.
And let it be noted that the author is an attorney.
Mr. Chair and members, Caitlin Vega for the California Labor Federation, also here in support. Commission workers already have a tremendous amount of uncertainty around what they're going to earn. At the very least, they should be clear on the terms of the commission agreement. So we're here in support.
Thank you.
Shane Gussman on behalf of the Teamsters in support.
Any other witnesses in support? Any witnesses in opposition? Perhaps any attorneys? No. All right. Would you like to close, Senator?
No, thank you very much, members. This clearly is something that, it's hard to understand why it was done that way, but and perhaps it was because people thought you would have legal recourse in California. Courts have now said that that is illusory. We need to put all commission workers on the same footing. Ask for your aye vote tomorrow.
Sorry. Senator Weiland, I'm sorry. Has a comment.
I was just going to ask why any employer wouldn't do that. And then all of a sudden, I began to realize that in our small business, I think we did it without that. Yeah. We never had a problem, but it makes sense to have it in writing. It must be mostly small employers who just have an understanding. Yeah,
it's small commissions. I think clearly the statute does exempt bonuses, and it's not about bonuses, and it's not about those kinds of things. It is clearly folks who are working on a straight sales commission kind of basis.
Thank you, Senator. We will take action tomorrow. Senator Hollingsworth. Welcome to the committee, Senator. And I'm sure you've been told this, but perhaps your witnesses or others, I'm sorry to be redundant, the committee is meeting to hear presentations and testimony, but because one of our members, Senator Yee, is unable to be with us, we will actually have votes tomorrow after session, after we get the necessary waivers. Senator.
Thank you, Mr. Chairman. Members of the committee, I'm here to present SB 989, which makes a very small modification in the Private Attorneys General Act, which is oftentimes cited as the Sue Your Boss law. I think it'd be appropriate if I begin by stating what the bill does not do, because there seems to be a lot of misunderstanding circulating among opponents as to what the bill is actually all about. First, the bill does not allow the Labor and Workforce Development Agency to interfere in any way with actual settlement agreements. The agency would not be able to comment on or veto an agreement, and the bill in no way interferes with the court's role in approving or disapproving Private Attorneys General Act settlements. And this is also unlike settlements that I might point out involving health and safety violations, which not only require notice to the Division of Occupational Safety and Health, but also allow for comments by the same agency. Secondly, this bill does not further complicate the process. The notice provision should not be seen as a hurdle. It's no more burdensome than sending a letter, and I'm fairly confident that someone who can navigate the procedural processes for filing such a claim under the Private Attorneys General Act would have no difficulty with sending a simple and timely notice to the labor agency. As of now, the awards of penalties and civil actions are to be distributed between aggrieved employees and the agency. The agency then earmarks the money for labor law enforcement and education programs. The problem is that there's no mechanism ensuring that they're even made aware of these settlements. Without this information, the agency cannot be sure that it is receiving its proper percentage of any assessed penalties, and it may not be made aware of specific problems in any industry as a result. Members, this measure is consistent with the professed intent of the original act, and it is to protect workers and educate employers. In fact, SB 989 would actually enhance the Private Attorneys General Act, which I don't know why I would be carrying this bill if that actually. I think it stands to reason that it does further the expressed interest of the Act by helping the Labor Workforce Development Agency in educating employers, protecting workers, and bringing about compliance, which is why I'm carrying the bill. To know where those potential problems are within industries and providing additional resources to educate employers and protect workers, I think should be every one of our goals. So I would ask for an aye vote, Mr. Chairman, when the committee reconvenes tomorrow.
Thank you. Witnesses in support.
Good morning. Kyla Christopherson here on behalf of the California Chamber of Commerce. We are pleased to support this legislation. It's simply a way to inform the labor agency of settlements that have occurred to ensure that they can ensure that they're receiving the sums that they're owed in terms of the penalties, which are 75% of what is assessed against an employer. And there's already been discussion in this committee earlier this year in the context of another piece of legislation that the labor agency right now is having difficulty in collecting penalties and enforcing penalties. So this is simply something that will help facilitate that process, and something clearly that's of concern at this time when the state is going through a number of fiscal difficulties. In terms of the Private Attorney General Act, it has, it's called the Sue Your Boss law. Clearly it's been problematic for the business community over the years. We appreciated earlier reforms that helped curb some of the abuses under the law, but unfortunately, as we understand, it's still being used against some small businesses in the context of settlements being extracted from them under threat of penalties, even when they have a defensible claim. Most small businesses can't afford to go to court. So there are still some concerns that the business community has under this law, and we think that this legislation will just help to ensure that settlements are being processed appropriately, and we think it's a very limited and modest reform. Thank you.
Thank you. Other witnesses in support?
David Vandergriff with the California Hospital Association in support.
Okay. Any others in support? Any in opposition? Senator
Well, he's
DeCheney.
coming up, and maybe he can answer that. Senator, I appreciate the point that you weren't trying to have the agency. I was trying to read in the statute why somebody might have thought it was allowing the agency to intercede in the proceeding, and I'm wondering if you considered the possibility of notifying upon the settlement rather than prior to the settlement, and if that would eliminate any of the concern that somehow that would throw the agency into the middle of it, if that was not your intent.
Actually, we've discussed...
Because the part about having the agency know the money's coming, I like that part. So
Right.
I'm trying to figure out.
Well, actually, we've talked about bringing those actually together, and it would be something that I'd be amenable to is to actually amend the bill to say that the notice is filed at the same time.
At the time of the settlement or upon settlement. You know, that they should be notified of the settlement and the terms thereof rather than sort of this advance notice thing that gives people the impression that somehow the agency's going to muck themselves
Right,
in the
upon
middle
the
of it.
settlement, the notification, that type of amendment would
Within
be
20
amenable.
days or something. Maybe it's the other way around. Just a thought.
No, I
Let's
think
hear
that
from the
would be a-
opposition.
Might be a
That's
good
still within the
compromise.
intent
then.
of the bill, correct?
Right.
Mr. Chairman and members, Mark Schock, California Rural Legal Assistance Foundation. Let me just suggest that the proposal that we'd have a post-settlement notification of the agency is unnecessary. And the reason it's unnecessary is because once a settlement or judgment is entered, it will direct the defendant's attorney or the plaintiff's attorney to provide to the labor agency any monies which are due it. And in fact, the failure to comply with an order approving the settlement is contempt. And contempt is punishable by a fine or imprisonment. Secondly, additionally, and independent of any contempt proceedings, an attorney that represents a party in a PAGA action has an obligation to comply with any order or judgment of the court, and failure to do so is a violation of his oath as an officer of the court and is a basis for suspension or disbarment. We are unaware of any single instance in which the DOSC, the LWDA, was not properly paid as a result of a settlement of a PAGA action. And so we would respectfully ask for your no vote.
Given that you just send them money, do they know what the terms of the settlement were, what the case was about? Do they know what what knowledge does the agency have of these lawsuits outside of somebody just, I got this stray check today? I mean, that's kind of the...
Well, that's not the way we do it. We attach, when we're the party obligated to send it, we attach a copy of the order with the check.
So why is that problematic to just say, yeah, you have to do that? I just don't see a whole lot of interference with anybody's rights here.
Yeah, as I said, I think it's unnecessary.
If it's best practice, then maybe some people may not be as...
Yes, sir.
Thank you, Mr. Chairman and the panel. I appreciate the opportunity to speak on behalf of CELA, the California Employment Lawyers Association. We, too, see this as unnecessary. The LWDA gets notice of these matters at the front end, and these are cases. The cases we're talking about are the ones that the LWDA looked at and turned down. The money they get from these cases is money they never would have seen under any other circumstances anyway. We believe it can be bad for workers because if the LWDA expends the staff time necessary and decides that it should get more penalties, the attorneys for the workers are in no position to simply say, okay, the workers will take less money so that the state can have more penalties. They've negotiated this in the workers' interest, and they're just in no position to retreat from that. So it's going to lead to extended litigation and potentially more penalties.
But why would it do that if all you're doing is telling them about it and they're not getting in the middle of it?
Well, but they'll have the ability to get into the middle of it, at least under this bill.
Why? What in this bill does that?
Well, what's the point of why would they? What would be the point of the notice otherwise if they didn't think they were going to get more penalties by potentially intervening?
So that they'd have notice that somebody owes them money.
But the court is, well, then it goes back to the point that was already made. The court is issuing an order.
Why is everybody acting like this is so burdensome? I feel like I'm missing something here. There's some sort of elephant in the room and I'm not seeing.
Well, we believe it's just going to be a way to impede these settlements. Ultimately,
black helicopters from the water.
Well, I don't think it goes that far. I do believe that this is an opportunity for the LWDA to slow down these settlements and potentially to blow them up.
So would my amendment solve that problem if the notice is upon settlement rather than 20 days in advance?
Well, what does it mean?
Within 20 days of settlement?
Well, what do you mean by upon settlement?
The settlement being approved by the court.
On final approval?
Of the court.
On final approval of a class settlement.
Oh, are they class actions, these things, mostly? I presumed they were mostly
generally,
individual.
No, they're mostly class cases.
That's section?
Mostly they are. Well, the PAGA portion doesn't have to have certification, but usually they come in conjunction with certifications of labor code claims. So there's an allocation between wages on the one hand and
but there is a settlement.
penalties on
the
the
court
other.
Is approving, someplace along the way, a court approves a settlement if it's a settlement.
Right, it's a final approval. We have less problem with it if it's a notice at the after final approval, because we believe that having the notice before that is unnecessary. The LWDA has had its notice at the front end, and the courts are overseeing the fairness to all parties. That's their role. I saw the argument made that we have no assurance that the LWDA is going to get its proper percentage of the penalties. I trust the courts to be able to multiply a number by 0.75. I've never seen them get it wrong. In fact, they've never had to correct anything in any agreement that I've been involved with because we did the math correctly. If anything happens that slows these down, it's going to be bad for workers. It's going to be bad for the courts because the litigation will continue instead of being wrapped up.
The senator said it was not his intent to have them be able to intervene, only that they have notice.
Well,
there's nothing in the
bill that requires that. That allows them to intervene.
Does the fact that it's not in the bill take away the implied right to intervene? I mean, if they're getting notice, why are they getting notice? If they don't, and they are an interested party, so why would they not be able to? The bill doesn't preclude their intervention. It simply doesn't expressly authorize it. But if they're an interested party, why wouldn't they be able to intervene? And if they do, and in order to know whether they should intervene, they're going to have to spend a lot of staff time. These are not simple matters. They're complex cases, at least the ones I'm involved with are. And so you have a case where if you're really going to try to understand what you think, the allocation, for example, between penalties and wages, because I'm tight, you're going to have to really spend significant time trying to come up to speed on it. So again, if they don't agree with plaintiff's counsel, that's going to delay the settlement. It's going to delay payment to the workers who need the money in an urgent way. It's going to delay money to the state. So the expenses imposed not only on the courts, but also on the LWDA, and it's a delay for the workers. It seems to me it's unneeded and expensive and bad for workers.
Anything else, Senator DeCheney? Clearly you have a member who's has some background in this and is concerned.
I don't have a lot of background, but it just seems Senator Hollingsworth's point is well taken. And if it were upon, Senator can consider it for tomorrow with your sponsors and folks, but it seems to me if it was within 20 days of final settlement being approved, that maybe solve the problem. But I don't know how that works for real. I don't know that. I never did employment law. I tried really hard. I did a little workers' comp once and twice, but I never really did employment law.
Thank you,
Senator Leno.
So, with less experience than Senator Cheney, not familiar with PAGA, I'm trying to determine, given this volley back and forth, that with a decision by the court that they're going to be notifying LWDA anyway. So then there's the question is, does the bill really do anything beyond what's already current? So may not do any good. Does it do any harm? And are you suggesting that even if with Senator Cheney's amendment that it be communicated after the final decision, that there's still the opportunity for LWDA to try to intervene post-decision? Because if that's the case, then they could even do it with or without this.
Well, and I don't know what happens if they are notified after final approval. I mean, it's a judgment at that point. So what rights?
That's the deficiency that we're trying to correct. Is there is no notification. There's nothing, and there's no way to know whether that check is of the right amount.
Well, the check. We're talking about a check that's 75% of the total penalties. The courts are well capable of doing that calculation on the off chance that the parties would get it wrong. I personally would be scared to death to get that wrong in the first place, not just because from an embarrassment standpoint, but from a liability perspective. This is the, this is. It is a solution in search of a problem. From that standpoint, I think it's a solution in search of a problem. We have much less problem with it if it's after final approval. We're talking about decisions here, and I'm looking at it from a class action perspective. In a class action, you have preliminary and then later final approval. If it's after final approval, I'm much less concerned. But then it just seems like, what are we doing? I guess we send them a copy of the settlement agreement?
There are two basic points to the bill. One is for us to know that the state is getting the correct amount from the settlements. The other is to know what types of settlements are occurring out there so that we can take the education programs that are supposed to be funded by these fines and tailor them towards the type of violations that we're seeing and actually do something good with those dollars that we're collecting under the original intent of the law.
My thought in response to that, if I may, would be...
Are we here having a debate, Mr. Chairman, or are we hearing the bill? I thought it was committee members
I guess
who were
I'm
questioning
consistent with what Senator Leno mentioned, not being an attorney, but being a former employer and never having been confronted with this, is sort of both what is the problem, and it just seems like the solution, if there is a problem, and it sounds like there may be, although from my perspective it may not be a large one, that Senator Duchesne's suggestion is pretty much holds your clients harmless and just adds to better communication, transparency. But I may be missing something. Other opponents? Senator Weiland, as they come forward, did you have a comment or question, or do you want to hold it?
Just a really brief one in regard to Senator Hollingsworth's last comment. I think in the Assembly, I probably was the only Republican who voted for mandatory requirement for sexual harassment training supervisors. And the reason I did that was this same issue, that I saw lawsuits and claims being generated out of ignorance, a lot of them out of ignorance. And those claims were unnecessary, and these are never fun things for the parties involved. And I think if we did know more about where they were arising, we could get better education, and you just have better workplaces as a result. So, just a comment.
Okay, thank you, Senator.
Mr. Chair, members, Caitlin Vega for the California Labor Federation. Our opposition was focused on the idea that the labor agency did already decline to pursue this case, leaving the worker kind of on their own to try to figure out what to do to proceed. And then once they were able to, get back unpaid wages or get back missed meal period wages, that then the labor agency would potentially be able to come in and mess around with the terms of the settlement or delay it or something like that. I think for us it was focused on a pre-final settlement intervention by the labor agency.
So, would Senator Duchesne's amendments change that?
I think we'd be interested in looking at the language, but that was the root of our opposition.
Okay, thank you.
Chair members, Doug Kim with the Applicants Attorneys Association. We oppose for the same reasons, and I would just point out the reason the Labor Code Private Attorneys General's Act was enacted in the first place is that the agency was either unable or unwilling to take the actions on behalf of the workers who now filed through a Private Attorney General's Act.
Having notice of the settlement, then they might start to see a pattern that might cause them to decide that they want to take up certain kinds of cases that they aren't taking up now. I mean, I don't know.
Thank you, Mr. Kim.
Mr. Chair and members, Paloma Perez on behalf of Consumer Attorneys of California. We are in opposition of the bill in its current form. I think that Senator Duchesne's suggestions might be worth looking into. Thank you.
Mr. Chair, members, Deanna Firm on behalf of the California Nurses Association. For the reasons previously stated, we also are in opposition.
All right. Senator Hollingsworth, would you like to close? And given the comments by committee members, maybe there's an opportunity for...
In the next 24 hours, we'll be looking at some language, hopefully, that will come back and address some of these issues.
We would love to pass a Hollingsworth bill out of this committee. That is meaningful for workers. All right. Thank you. That ends our items for today. So the plan, committee members, is to reconvene upon adjournment of the session tomorrow. Thank you all. Thanks everyone who testified.